Welcome back. In the previous videos, you have learned about the principles and practice of international arbitration in several different settings. Interstate arbitration and investment treaty arbitration in particular. In this module, we will focus on the interplay between state immunity and the validity and enforcement of international arbitral awards. What are the conditions for a valid award? What happens after an international arbitral award has been rendered? Can an award be invalidated? How are arbitral awards enforced? These are the main questions we will discuss together in this module. In the final video, we will look into the UCOS arbitration, a complex case in which an award was invalidated while the enforcement procedures continue. We will be looking at the stage after the arbitration proceedings. When the proceedings have come to an end, the arbitrators settled the dispute and rendered a final award. Rendering a final award implies that the mandate of the tribunal has come to an end. The proceedings are closed. This is also why, except in certain limited situations, the procedure that relates to the enforcement of an award is conducted outside of the formal setting of the arbitral tribunal. An arbitral award is a written decision by the arbitrators in which an answer is given to the issues and questions submitted by the parties to the arbitral tribunal. The result of an arbitral award may vary, depending on the agreement between the parties. It may be in the form of an obligation for the unsuccessful party to pay a certain amount of money, or a non-financial award to abstain from a certain action. An arbitral award is binding and final upon the parties. That is why the successful party will expect the opposing party to comply with the award voluntarily once it has been rendered. If the unsuccessful party does not perform the obligation under the award, the successful party can initiate recognition and enforcement proceedings. Before commencing an enforcement proceeding, it is important to make sure that the award is valid. To have a valid award, it needs to meet certain conditions outlined in the rules chosen by the parties. Usually, certain formalities are required. An award has to be in writing, dated, signed by the arbitrators, and the place of arbitration agreed upon should be mentioned. Such conditions will be based on the rules which the parties have agreed upon. Secondly, and perhaps most importantly, the award should state the reasons upon which it is based. This is what we call the obligation to render a reasoned award. This is important to ensure the legitimacy of the arbitral process, notably from the perspective of the parties and the public in case of treaty-based investment arbitrations. Thirdly, the award has to be communicated promptly to the parties to the dispute. The fourth requirement concerns the time limits for the arbitrators in which the award has to be rendered. The time limits are always calculated from the beginning of the proceedings until the final award. This usually is also provided for in the arbitration rules that are used. When it has reached the time limit, the authority of the tribunal is at an end, and it no longer has jurisdiction to make a valid award, unless, of course, an extension has been granted. The fifth requirement is that the award should answer the issues defined by the parties. A tribunal should not either fail to decide the issues, nor decide issues not submitted by the parties. This is called an excès de pouvoir, or excess of authority. A valid arbitral award is important for the award to be recognized and enforced. It is also important to point out that these conditions may vary from the different parties' agreement, including the rules of the arbitral institution the parties have chosen. In this video, you have learned the main requirements to have a valid and enforceable decision. We will next consider what rules apply to the enforcement of arbitral awards.